Is it on? Mm-hmm. I'll wait till it's on.
And this is how this meeting's going to go. He's here, bring information from the board, such as a half hour he's going to do, and the rest is going to talk to the board. No interruptions, no questions from the public. He's here for the board, except for the first half hour. Go ahead.
Thank you. My name is David Slottje. I am a senior attorney with the Community Environmental Defense Council, the pro bono public interest law firm. I'll be quick, try to go through and respect the full of your time. I want to talk today about using local land use authority to protect health, safety, and community assets in the face of certain industrial uses, specifically gas drilling. Brief overview of what I'm going to talk about. Using your land use authority that you have to address gas drilling, powers of local government in a vacuum. Our recommendation, which is if you're undecided or if you need time for something such as a road use agreement, a road use law, that you enact a moratorium. What the so-called gas mining statute is and what the status of the law is regarding preemption on that. And talk about common arguments made against by people who might not want you to pass this kind of law. I want to talk about the Binghamton decision, and if we have time, I want to talk about compulsory integration. And I'll try to go quickly here. So, as a general matter, in a vacuum, and I apologize for having my back to you folks, but I am presenting to the board. As a general matter, what powers do local governments such as the town boards have in our state? I should first tell you that everybody knows that the United States Supreme Court is the highest court in the land. In New York State, the Supreme Court is not the highest court. The Court of Appeals is the highest court. So when you're listening to a lawyer talk about New York law, we recommend that you have your ears prick up when you hear Court of Appeals, because that's the last word in New York. That's the highest court. Every single case that I show you, unless I tell you otherwise, you don't think there will be any, every single case that I'm going to show you like this is a Court of Appeals case, the highest court in the state. So, what has the highest court in the state said about what kind of power town boards such as yourselves have? Well, it's a legislature's right, you're the legislature, and particularly in matters of land use, this court says, the highest court says, an obligation, in fact, to anticipate future problems and to enact measures to guard against them, even if those anticipated events never come to pass. So what the highest court of the state has said is not only do you have a right to look at something like this and make an informed guess, you don't have to be perfect, but they actually say it's your obligation. All right. There is something called the Home Rule Law. Some people think it's a concept, and it is, but it's also a statute. It's an existing New York State statute. And this municipal home rule law vests towns with the police power to enact laws for the protection and enhancement of your physical and visual environment, and for the protection, safety, health, and well-being of persons or property therein. So in a vacuum, I'm going to tell you in a minute why we're not working in a vacuum. But in a vacuum, there's no question that you've got the legal authority and the power to pass the kind of law that I'm going to talk about, and that the municipal home rule law, which is a state statute, gives you precisely the type of power that you would need if you were interested in doing something like this. By the way, if anybody is interested, I'm happy to provide copies of this PowerPoint electronically, if you give me an email or so. Okay? Our recommendation is that municipalities, towns which are not certain whether fracking as presently practiced is appropriate for their community, either because residents are divided or members of the town board are themselves undecided, should preserve their options by considering the enactment of a specific but common type of land use law called a moratorium. And I'll explain in a moment exactly what that is. And in the event that you do that, enact a moratorium, we think it should be enacted before the DEC begins issuing drilling permits. Notice that I said fracking as presently practiced. These people have gotten a lot better in the last 2.5 years, the drilling people, compared to where they were 2.5 years ago. And there's every reason to think that they're going to be a lot better in 6 months and a year and 2 years from now. So what we're focused on is what the state of the technology is right now. Before I get into how a moratorium works and what a moratorium is, I want to tell you some things that it isn't. Very, very important point. A moratorium is not zoning. And enacting a moratorium does not somehow magically turn a town into a place that has zoning. You will never, ever, ever hear a lawyer tell you that a moratorium turns your town into a place with zoning. The only people who believe that are not lawyers. As a matter of law, the moratorium is not zoning and does not turn a town into a place that has zoning. Second very important point about moratoriums. Consideration by a board such as this as to whether a moratorium should be enacted or a decision to enact a moratorium after that does not mean, once again, as a matter of law, does not mean that the board members have made up their minds about whether gas drilling is an appropriate land use in the town. All a moratorium is a timeout. It is not, if you decide to go with a moratorium, that does not mean that you're somehow declaring that you're against gas drilling. The only thing it means is that the people who vote for that believe that it's in the best interest of the town as a whole to study and gather more information during the moratorium period to help them make an informed decision. A moratorium is like any other law, local law that you've ever seen. It's like a dog catcher law, any other law you've ever looked at. The only difference with a moratorium is that the moratorium has an expiration date, a burn-off clause in it. Okay, so it'll look like any other law except there'll be one sentence that says this law goes away in whatever period of time we're talking about. Some people describe a moratorium as a temporary law as opposed to a so-called permanent law. I don't like to do that, and I think it's very important to remember that even a non-moratorium law, in other words, one that doesn't have a burn-off date, every single law that you would ever pass is subject to repeal. You could pass a law on any subject, gas drilling, dog catchers, whatever you want. That law could specifically say we can never, ever repeal this law, or we can't repeal this law until it's for 6 months. And that's ineffective. You could turn around and repeal the law the next day. So it's very, very important to remember, whether we're talking about a moratorium that does have a stated expiration date or some other kind of law, you can repeal it any time you want. All right, what does a moratorium look like if you haven't seen one? They're very simple. Here's the guts of it. From and after the date of this law, no application for building permit, or other town level approval shall be approved for the use of any land or body of water located within the town for any of the following. And then whatever the subject of the moratorium is, gas drilling activities in this case, we put in there. I'm not going to take your time to go through what's in one of our moratoriums, should you decide to go that way. I just want to make one point to you. One of the things that we deal with in our moratorium is natural gas and petroleum extraction, exploration, or production wastes. And I want to explain just one thing, this one definition that we use. If you look at our moratorium on this issue, it starts by saying any of the following in any form, whether or not such items have been accepted or exempted from the coverage of any federal or state environmental protection laws, or have been accepted or exempted from statutory or regulatory definitions of industrial waste, hazardous materials, hazardous substances, and so forth. That's a very, very unusual way of drafting. And I want to just explain to you why we do that with our definition of waste. Most people know that, based on the so-called Halliburton loophole of 2005, that the gas industry is exempted and accepted out from the Safe Drinking Water Act. What most people don't know is that we've got the same issue with respect to virtually every single federal environmental law in this country. The Clean Air Act, the Clean Water Act, CERCLA, which is a Superfund law, RCRA, which is Superfund law on steroids. All of those laws follow the same three-part format. The first part basically sets forth or articulates whatever compounds and chemicals the law is dealing with. So it says benzene, xylene, toluene, whatever it is, and it goes through the whole way. And at the bottom of that, still section 1 says any one of the foregoing, is herein referred to as, and any two or more are herein collectively referred to as, and then depending on the law we're talking about, it'll say industrial waste, hazardous materials, hazardous substances, and so forth. Then you've got Part B, which I'm going to come back to. Then you've got Part C. Part C says that any person who handles, transports, utilizes, disposes, any verb you can think of, any hazardous waste, industrial materials, hazardous substances, and so forth, shall be subject to this law. Whatever we're talking about, Clean Air Act, Clean Water Act, CERCLA, etc. And then depending on the law, and including the applicable regulations, you've got hundreds and hundreds of pages that are supposed to govern the use of that particular chemical. But the Section B that I skipped is no more than 2 sentences, and usually 1 sentence in each of those laws. And it says, notwithstanding any provision hereof to the contrary, in the event that the person, and person is defined expansively, who is utilizing any verb you want, handling, etc., one of the compounds in Section A, if that person is under contract to, employed by, or associated with the oil and gas industry, then, and in such event, that compound in Section A shall not be a hazardous material. So, what that means is, if anybody else in the entire country, no matter what they do, whatever kind of industry, is handling, say, toluene, or xylene, or benzene, that benzene, that xylene, toluene is, depending on the law, hazardous waste, hazardous substance, hazardous materials, toxic substance, and so forth. But if that chemical or that compound is being utilized by somebody in the oil and gas industry, and that's the only industry, then in that event, that's not hazardous. So if you decide you don't want this kind of definition, because like most clients, you'd rather have a short law than a long law, and you say, look, just do a law that says thou shalt not use, or let's just say spill, forget drilling, you're just dealing with the waste. Thou shalt not spill or dump hazardous materials, hazardous substances, and so forth in our town. You've got a big problem, because when your code enforcement officer goes to give an appearance ticket or whatever we do in this town to the person who spilled that, they're going to say, no, I'm under contract with, associated with, under employment with people in the oil and gas industry. And when I do it, including when I dump it, it's not hazardous material. It's not hazardous substance. That's a fact, and you should only get, I recommend that you only listen to lawyers on that issue. And if you get another lawyer who tells you that's not true, send him to me. That's federal law. Okay, moratoriums. I'm going to talk about Binghamton in a minute. So, the legal authority that I showed you, as I said, occurred in a vacuum. We're not operating in a vacuum. There's also a state statute called the gas mining statute. It's Environmental Conservation Law 23-0303 subsection 2. And some people, not very many people, certainly not many, I only know 5 law firms, fewer than 5 law firms in the state who disagree with what I'm about to tell you at this point. But some people will tell you that this gas mining statute preempts or takes away your legal authority to pass the kind of laws that I'm here to talk to you about. So let's look and see what that statute says. It says you don't have any authority to pass this kind of law, a law relating to the regulation of the oil, gas, and solution mining industries. You know what oil and gas are. Solution mining is salt mining. So, we know you don't have the law, you don't have the authority to pass a law relating to the regulation of the gas industry. What does that mean? What the Court of Appeals has said, again, that's the highest court in the state, in a slightly different context, the gravel mining context. But they said it unequivocally, repeatedly, and unanimously each time they said it. Those are things that mean a lot to lawyers. What the Court of Appeals has said unequivocally in that slightly different context is that the legal effect of language virtually identical to the gas mining statute relating to the regulation is that while a town may not regulate the operations and processes of a particular industry, which is the subject of that language, the town may in fact prohibit the industry altogether using land use laws of general applicability. I'm not here tonight to talk about this. That would be a so-called permanent law, even though I don't like the term permanent. But believe me, if you can do it permanently, you certainly can do it temporarily with a moratorium. All right. So, there are only three cases in New York State at any level that specifically consider the question of whether or not a town or local municipality in New York State has a legal authority and power to pass protective laws with respect to gas drilling. There are only three decisions. All three of them, well, let me show you how they are. The first is Dryden. That was the first case that came down. That was 221. There are no other cases, no matter what anybody tells you. And that's why I've got the first sentence of this decision is this is a case of first impression. What that means in lawyer words and the judge's words is there are no more cases out there. So when people on the other side tell you, well, there's another case out there, there's not. That other case contains language that they like, but it's not on point. That other case was briefed in all three of the cases that I'm going to talk to you about, and all three times it was ignored. Not because the judges are prejudiced. I'll explain, one of these judges is the cousin, literally the cousin, of State Senator Libis, who's the #2 guy in the State Senate and who bleeds fracking fluid. He loves fracking so much. And his cousin wrote one of these, which I'll show you, okay? So what this said unequivocally, the gas mining statute does not preempt a municipality's authority to completely ban operations related to oil and gas production within its borders. That's Dryden. 2 days later, Middlefield came down. Exactly the same thing. Municipalities are not preempted by ECL 230303 subsection 2 from enacting local ordinances which prohibit gas mining. Now, in respect to your time, I'm going to pick this up. There's a lot of interesting stories in the background here, but each one of these, the people on the other side said, the courts will never say that. And then when it came down, they said, well, that judge is prejudiced, or that judge is a Democrat, although that judge that they were talking about wasn't a Democrat, he was a Republican. And then they said, well, it came from Tompkins County, and they might as well be red. Well, the third case came from Broome County, the Binghamton case. And as I said, the judge in that case is, his name is Libis, spelled differently, but he is State Senator Libis' cousin. And here's what he said. There's a lot of misinformation being floated about what happened in the Binghamton case. I'm going to talk about that today. But here's precisely what Judge Libis said about Binghamton. He described those Dryden and Middlefield decisions that I just showed you as well-reasoned and well-founded. And he specifically adopted the reasoning of those cases as his own. So there are only three cases at any level in New York State that address this. And all three of them say exactly the same thing, literally the exact same thing. In this case, he adopted it as his own. Okay? Now, when people tell you to wait for the appeals, you may or may not know that gay marriage is legal in New York State now. It wasn't legal, say, 2 years ago. So if somebody, if a Shenango County judge 2 years ago came out with a holding that said gay marriage is legal because it would be unconstitutional to make it illegal, in that situation, I could see somebody saying, wait for the appeal. That would make sense to me because there's no other body of law out there in New York State that says what that case says. So yeah, we should probably wait. In this case, wait, what are they waiting for? Tom West, who is actually appealing Dryden and Middlefield, who tried those at the trial court level, Tom West is on record saying that he doesn't think they're going to win the appeal. He has said that in front of cameras. Nobody thinks they're going to win that appeal, which, by the way, is being argued on March 21. There are people who hope they will on the other side. Nobody believes it. Okay? Again, talk to lawyers about this, not the people who want a particular outcome. All right, so I've got to pick this up. So all three cases agree. They're the only cases that have specifically considered it. They've unequivocally held that towns wishing to do so do have the legal authority to pass local land use laws to prohibit gas drilling activities within their borders. There is not a single New York case at any level that holds to the contrary. Not one. All right, I'm going to speed ahead here. Here is just talking about some of the arguments that are made against this. This is, again, these are Court of Appeals cases. I'm not going to go through the headings, just I'm going to pick up, go fast in time. The town is not obliged to permit the exploitation of any and all natural resources within the town as a permitted use if limiting that use is a reasonable exercise of its police power. You don't have to have zoning, we're talking about police power, to prevent damage to the rights of others and to promote the interests of the community as a whole. People will tell you this is not the law in West Virginia, they will tell you this is not the law in Pennsylvania, they will tell you it's not the law in Colorado. That's right. But this is the law in New York State, because in New York State, look at what's in blue. What always trumps things under the New York State cases, and that's where we are, is preventing damages to the rights of others and to promote the interests of the community as a whole. Okay? One argument people like to say is, look, we're not engineers, or you people on this board aren't engineers, and you are not, frankly, smart enough, or the town citizens who live here aren't smart enough to make the decision. We have to leave it to the DEC. That is what the lawyers call a red herring. That is not a real argument, because there is a huge distinction between the need for statewide regulation of the process of fracking, if you assume it's going to take place, and the entirely local decision of whether or not to allow fracking as a land use within your town. You don't need to be some kind of engineer to figure out whether this land use is appropriate for your town. Anybody who tells you otherwise is mistaken. What all three of those cases say, the town gets to decide whether or not a particular land use is appropriate. And if you decide it is, then in that case you rely on the DEC to decide how the gas drilling proceeds. All right. We'll be sued. They tell you, look, if you pass one of these protective laws, you will be sued. What I can tell you is that my wife and I have, just my wife and I alone, have worked with over 100 communities of all sizes, the largest in upstate New York, and towns of 600. And there are probably 150 towns that have passed these kind of protective laws. We've worked with over 100 of them. And of the 100, virtually in every single case, somebody has come in and said, if you pass one of these laws, we're going to sue you. We guarantee we're going to sue you. We promise we're going to sue you. In fact, here's a copy of the papers we're going to use to sue you. But of those 150, number 2 got sued and won, number 4 got sued and won, 2 got sued, which I'm going to talk about. Everybody has won. Then they say, okay, well, even if we're going to win, we can't afford the lawyers' fees. I'll pick this up, but there are free lawyers, very good free lawyers, 200, 300, 400 lawyer firms, that if a town wants to and has the right kind of law, they will represent the towns for free. The only risk in these cases is your legal fees. These are not the kind of lawsuits, despite what people were threatening 2 years ago with takings and things like that. These are not the kind of lawsuits where financial damages are part of the suit. Your risk here is simply legal fees. And there are really, really good lawyers who will do your legal fees for free if they're happy with the law you do. I'm going to come back to that. I'm running out of time, but I want to talk about the Binghamton decision. There are many different issues in the Binghamton decision. Here's what's really, really important to understand. Both sides in the Binghamton decision are appealing. Both sides. Okay? Now, I'm going to start by showing you what the landowners' side, what they're appealing. These are things they have to win. They have to turn over below, in the decision below, to win. So these are some of the things they lost. First of all, whether towns have the legal authority to pass these types of laws. Because that judge held, as I showed you, specifically that they do. Specifically agreed with Dryden and Middlefield. Secondly, whether protective laws must be zoning laws. Those are just 2 of the things that the other side, well, we haven't seen their papers yet. We haven't seen the briefs. But those are 2 of the things that they're appealing. So when everybody says Binghamton, Binghamton, everybody should know about Binghamton, Binghamton. Both sides are appealing. And that's what the landowner people are appealing. Whether towns have the legal authority to pass those laws. The landowners lost that. They've lost it 3 out of 3. They lost it in Tompkins County, they lost it in Otsego County, and they lost it in very, very conservative Broome County. So we're past the point where people can say, well, anything that happens in Tompkins County doesn't matter. This is Is McDonough a member of the Association of Towns?
Yes.
Okay, so this is from the December issue of Talk of the Towns, which is the paper from the Association of Towns. I'm just showing this briefly because in case people don't, for whatever reason, not that you doubt me, but in case you somehow don't believe what I said, this is from the December issue of Talk of the Towns, talking about the Binghamton case. And moving to the merits of the law. Merits to a lawyer, the other thing is procedural issues. There are a bunch of procedural issues, and I'm not going to bore you with, that both sets of lawyers are fighting about. The merits is what it sounds like, the guts, the substance of the lawsuit. So moving to the substance of the law, this is the Association of Towns describing what happened in Binghamton. The court noted that the local law was not preempted. Despite what everybody on the other side likes to say, the court specifically held it was not preempted. This is the Association of Towns view, not mine. And the court specifically adopted the well-reasoned, well-founded decisions, close quote, of Dryden and Middlefield. The court recognized that the municipality may enact local laws pursuant to its police powers. You don't have to have zoning. And that those laws are not subject to review, etc. So you don't have to have zoning to do one of these laws. Okay? Now, here's what, and we represent the city and we represented the city below. Here's what some of what the city will be appealing, the city of Binghamton. I'm going to explain this because it's not going to make sense right now, but I'm going to come back. Whether at this time, as we speak, or specifically in November of last year when this decision came down, natural gas exploration or drilling can occur in the state. Not frack drilling, any drilling. And whether at this time, as I speak, and in November when the decision came out, gas drilling permits are being granted by the DEC, and whether same issue, whether they're issuing permits. Now let me explain why that's what we're appealing. The judge in the Binghamton case held that in connection with a moratorium, and I told you what a moratorium is, and a moratorium is not limited to gas drilling. It can be any, you can use it for any sort of thing. The judge there held that in order to have a valid moratorium anywhere in New York State, gas drilling or otherwise, you had to have dire necessity and immediate crisis. That you could only enact a moratorium in response to that. That's not right, but that's what he said. Then he said that that the Binghamton law was no good because there could not possibly be any dire necessity or immediate crisis because, he said, at this time, no natural gas exploration or drilling, he didn't say fracking, he said natural gas exploration or drilling, can occur in this state. And he said, no permits are being granted, DC's not issuing permits, our law covered all gas drilling, not just fracking. That's why he was talking about all gas drilling, not just fracking. And he said, therefore, the law fails. So, we're going to attack his assessment that to have a moratorium, one needs dire necessity or immediate crisis. But that's not the only thing we need. We don't need to win on that to win the suit. Even if he's right about dire necessity and immediate crisis, we can give that one away. All we have to show to win our appeal is that gas exploration and drilling is occurring in New York State, and it is. And the permits are being granted, and they are. That's all we need to do to win on our side. So, that's the gist of our appeal, whether at this time New York State has natural gas drilling and whether they're issuing permits. That's what we gotta prove. We can lose on whether the dire necessity, immediate crisis. We're going to challenge it. But even if we say, Judge, you're right, but you said in a gas drilling context, here's what you need, the permits, etc., we win based on that. Here's what the other side has to do if they're going to win. They have to overturn the finding that now 3 different courts from very different places, Tompkins County to Broome County, have said on the preemption. So, I don't know if anybody here is a gambling person. I'm not, but I'll take my chances because I'm pretty confident I can show that there's gas drilling going on in New York State right now. All right, let's see. Quickly. I'm not going to talk about compulsory immigration. I don't have time.
Well, go ahead again.
All right, thank you. It's just 5 slides. So, and I'll go fast. Many people assume that companies are legally allowed to frack. This is an important issue. I'm glad, thank you for letting me do this. This is an important issue because this goes to the property rights issue. This is the other side of the property rights issue when people say, if you don't let me drill, even on a moratorium basis, you're taking away my property rights. Here's what happens on the other side of the coin. Many people assume that companies are legally allowed to frack only on properties where they have obtained leases, and that if you don't want to allow your property to be used for fracking, or you haven't decided yet, you can stop them from doing so. But that is not the case. This, by the way, is the dirty little secret of fracking. This is the one thing, and this is what I do full-time, and I've done it for 3.5 years. This is the one thing, in my experience, that the pro-drilling camp does not want you to know about, compulsory integration. And New York law provides that fracking companies are not limited to using only the property that they have leased for drilling. In fact, industry proponents concede that they might not be able to drill profitably at all unless they are also allowed to invoke compulsory integration so as to be able to use the property of people who have not leased. Okay? I'll explain how it works. It's a two-part process. I'll pick this up, Supervisor. I just have 2 more slides. Here's how it works. Spacing units. Thank you. Normally don't speak this way.
Well, he doesn't start until 5 after anyway.
Okay, all
You
right.
still got 5 minutes anyway. You're good.
Thank you.
On the first one, then you still got 15 minutes left.
Thank you. Next comes the actual compulsory, I'm sorry. So the first thing is that spacing units are established. And a spacing unit is the area the fracking company wants to drill under. In Marcellus Shale, it's anticipated that the spacing units are going to be 1 square mile each, which is 640 acres. So they establish the spacing area, which is where the area they want to drill under. Next comes the actual compulsory or forced integration component. So long as the fracking company states that it controls at least 384 acres of that 640, or 60%, owners of the remaining 40%, or 256 acres per each spacing unit, are required by law to allow the driller to frack under their land. Required by law. So if they tie up 60% of the area they want, they can force drilling under the other 40%. And they have said, I won't back up because I don't, but they have said they need this. They couldn't drill profitably otherwise without it. Required by law. There is no way to opt out. It doesn't matter if you are against drilling or if you are for drilling, but you don't want your property drilled now while prices are historically low. You get no choice in the matter. Anybody who tells you otherwise, lawyer or non-lawyer, is dead wrong. Unbelievably, the compulsory integration law does not provide compensation for using their land to the people who are forced to participate. They do provide a share of royalties if the well turns out to be profitable. But there's no payment for drilling under your land. There's no payment for injecting and leaving fracking fluids under your land. There's no payment for leaving the wellbore under your land for years or perhaps forever. And there certainly is no signing bonus paid to you. That's why the drilling companies like this. They get 40% of the land without signing bonuses or anything else. Now, when I talk about this, typically the pro-drilling people actually use the L word. They call me a liar. All kinds of attacks. They say that my description of compulsory integration is inaccurate. It is not. It is very accurate. And I don't know if anybody here knows about, there's an online news aggregator called Marcellus Drilling News that you may or may not be familiar with. If you know about Energy in Depth Marcellus, Marcellus Drilling News is basically EID Marcellus for grown-ups, okay? Because all they deal with is serious things. Marcellus Drilling News hates me. But here's what Marcellus Drilling News said last summer when I sent something like this around with these exact words to newspapers all over the state. Here's what Marcellus Drilling News said. Their headline, I left off the rest, it made him vomit to say it if you read the thing. But as much as it hurts us to say it, we agree with Slottje. So, I'm telling you, I couldn't do this. I've been a lawyer for 31 years. I could not, if I misrepresented the law, I'm a lawyer in 3 jurisdictions, they could pull my ticket everywhere. every single thing I've said to you today about the law is accurate. And I appreciate your time, and I just want to leave you with one-page handout, if you're interested, which in one page explains the state of the law here. And that way, if any lawyer, as opposed to business person, sorry, you guys can share, says that the law is inaccurate, you've got what I sent, and somebody can send something to me, and I'll say, here's why I'm right and they're wrong. I'm happy to take questions now. I can wait. I can not have any questions. That's fine too. I don't mean to interject myself.
He's invited to have a seat. Is that not true?
Sure. Okay. Thank you.
In your presentation, although you didn't mention this specifically, but I think it would apply to in the town law manual on page 93. It talks about in Article 8 of the Environmental Conservation Law known as CCOR. And it talks about how a town, let's see, I'll just read it here. As implemented by Part 617 of the Department of Environmental Conservation Rules and Regulations, allows towns to adopt their own state environmental quality review procedures by ordinance or local law, as long as those procedures are no less protective than the state statute and regulations. So my question would be, with what I'm reading there, if the DEC regulations, in our view, don't adequately address a particular subject, I know I read one thing online where it stated under the new regulations, the gas companies would not be allowed to use diesel fuel as a base for their fracking fluid. Now when I read that, it's okay, it's not the base, but it didn't say it's not in there either. So, as a board, I mean, would we have the legal authority at such time down the road in the future, if we decided that yes, we would allow fracking in the town, would we be able to put our own environmental regulations in that might actually be more stringent than what the New York State DEC has said?
I'm not familiar with the statute you just mentioned, but I'll take the shot anyway. And the answer is, I believe you would not be. You would not have the authority to go beyond the DEC with respect to the drilling issues. In fact, the Court of Appeals, the highest court, has said repeatedly, you can't. The seeker process, I don't know if you know what seeker is, but seeker is any time that anybody, any government agency from Albany to the local sewage treatment facility, which is issuing bonds, anytime anybody's going to take any governmental action like that, you have to test it for its environmental impact. And that's what seeker is essentially, it requires you to test things for environmental impact. What that is saying is, if you want to create or employ your own environmental impact assessment procedures to supersede seeker, then you've got the right to do that, as long as you are you're at least as, but that doesn't, I didn't hear anything there that would tell me that would allow you to supersede or preempt the gas mining law. So what the gas mining law says, and what these court cases say, is that you can prohibit this particular use, but if you don't prohibit it, you can't say how it's done.
So what I described would be regulating. In other words,
well,
if we tried to say you.
Yeah, oh yeah, I'm sorry, absolutely would be.
Yeah, okay.
Yeah.
So you have to either prohibit it or just leave it
Right,
alone.
Right. I'm sorry. In the gravel mining context, where this same concept exists, for example, towns have tried to do things like they've said, you can mine in my town, but you can't use. They talk about types of mining that are allowed, manner of mining, I should say. So it's okay to do it, with machines. But this particular town said, we're going to let you, it's fine to mine with machines and people, but you can't use explosives here in this town. And the court said, the highest court in the state said, that might not be the highest court, but the court said you can't do that. You can say no to it altogether, but you cannot tell them they can do one kind of mining or manner of mining and not another. In another, where the town had said, yes, you can do gravel mining, the town said, but you can't use rock crushers. And the court said, you can't do that. You can tell them no at all, but you can't tell them how to do it. Using a rock crusher is part of the operations and processes. And what those I went very quickly and I apologize, but what those cases all say is what that language means about regulating the industry is you can't get into the business of how they do what they do. You can't get into the operations and processes of gas mining or gravel mining and so forth. So what you would be talking about doing, they would, I'm sure, say, and I would agree frankly, that is regulation.
Of course, you and I talked before, you guaranteed us in writing that you will stick with us no matter what happens.
Yes, and by the way, if, not only will we do that, if you're interested, and obviously at no cost, but if you would prefer, or you'd have a higher level of comfort with a larger firm or a national organization, the appeals in Dryden and Middlefield are being handled by Earth Justice, which is basically Sierra Club's lawyers, inside law firm, hundreds and hundreds and hundreds of lawyers, really good lawyers. I can't commit them, but I could. There was another town recently in your county that
Village of Oxford. Yeah.
Correct, I didn't want to say, but they passed a protective law, and, oh, speaking of, Harry, sorry, didn't mean to take your time.
That's okay.
How are you? How are you? Good. Where, before deciding to proceed with their protective law, the village council and their council, C-O-U-N-S-E-L, satisfied themselves that not only would we be available, but other organizations, larger organizations, would be available if a suit were filed. And your own counsel can tell you either in executive session or otherwise how he accomplished that, how the village accomplished it. But yeah, absolutely. If you did do this and you did it with a law that one of our laws, albeit that Roger sanctioned, we would absolutely stand by it. Again, there are no monetary damages in this kind of lawsuit. So your issue, your downside is your legal fees.
I would just put, I don't sanction or I don't ignore either, but basically, my job for the Village of Oxford, as it is for the town of McDonough, is to effectuate what these people want. The village decided to put in a moratorium. One of the concerns that the village had was the cost of a legal defense. And I would suggest to the town, McDonough, or any municipality, if that is a concern, and there are organizations out there willing to mount that defense at their cost, we'd be foolish not to take advantage of that. The other point that David's, quite frankly, there's 5 or 6 attorneys sued. This is all they do, and David's one of them. I'm not. I want to make sure everybody understands that. But my feeling is, until the Court of Appeals rules on an issue, it is an open issue. And everybody has different opinions as to what's going to happen. But until that happens, it's still an open book. And I think we'd be wise, if you are considering a moratorium, that you have that legal defense, in your pocket, if that's what you should decide to do.
I do not, if you decide to go that way, or if you just wanted to know before you decided, I don't anticipate, which would be very reasonable to want to know ahead of time. Although some people can't give you a commitment until there's a suit, but I don't anticipate any problem finding an organization that would, as happened in Oxford, that would step up.
It's like right now, as far as a moratorium, is there a maximum length of period of time that a moratorium can be enacted? Like a year, 2 years, 3 years?
What the law says is that no is the answer. What the law says is the duration of a moratorium has to be reasonable. That's the standard, reasonable, given the purposes and circumstances of the moratorium. You do moratoriums in different contexts, but there is no, despite these urban legends to the contrary, there is no law that says anywhere that says you may not extend more than X times, or you can't, for an aggregate of Y, period. But what you need to keep in mind is that you're supposed to be doing something with your moratorium, maybe considering a road use agreement or road use law or whatever. Yeah. And when let's say the first one was a year, and that the second one was 6 months. They will test it at the time of the first one. Is 1 year reasonable given what you're doing? When you go to extend it for say 6 months or whatever, now they're going to test it. It was 18 months reasonable given what we want to accomplish.
Who's going to test it?
Well, that's if it were challenged. If it were challenged.
The other moratoriums that are out there, how long are they?
We have never done one, with the exception of Binghamton, which we don't concede as a moratorium. We didn't want it to be a moratorium, and we did do Binghamton's. With the exception of Binghamton, which was 2 years, but which we don't consider to be a moratorium, we have never done one longer than 1 year initially. And we've never extended more than 1 year. And usually when people extend, they extend 6, 9 months. It depends on what they're trying to do. You would not want to go, there's no reason to go more than a year, because even if you anticipate that what you need is going to take 2 years or 18 months or 14 months, the safest thing to do, we would say, is go with the shorter period, because that's when they're going to test what's reasonable, and then add on later. So there's no percentage in going too long. It can only hurt you.
Now, what's the difference between a moratorium and a ban?
The only difference between a moratorium and a ban is that a moratorium has an expiration date. In a town that does not have zoning, like you guys, that would be literally true. The only difference in the law, there might be some bells and whistles, half a page worth. But in a town that doesn't have zoning, the only difference between a moratorium and a ban would be that 1 or 2 sentences that talks about the expiration date. In a town, because it's real simple, in a town that has zoning, the ban typically takes the form of a zoning amendment.
Now, the situation right now in Albany, I was reading in the paper, the Assembly has passed a 2-year moratorium until May of 2015. I guess it's being worked on in the Senate. I did read that Tom Livis is he's going to do everything in his power to make sure it doesn't come to a vote, which I made sure I wrote him and expressed my opinion. I mean, it doesn't sound real American to me, trying to prevent it from going to a vote. But if it did go...
You know who Mitch McDonough is?
Yeah.
Tell him.
Yeah. But if it does go to this, it passes in the Senate, so there's a statewide moratorium, and
even if it passes, it's just like at the federal level, the president has to sign.
right, and if
Cuomo has to
Cuomo
sign.
does sign it,
Right.
so it would be a 2-year moratorium. How would that affect what we're considering here? Would that give us like 2 years to just sit back and relax, or should we think about if we?
You'd have to be 2 years working on something.
There you go.
Yeah.
So it would give you 2 years.
first of all, it would give you 2 years if it happens, subject to what I'm about to say after what I'm going to say now. Second of all, that assumes it's going to happen. Not only Libis, who's the deputy majority leader, or the majority leader, I should say, but Skelos, who's the head of the Senate, he has actually said that it'll happen over his dead body, that the vote comes to that it comes to a vote on the floor. And I saw something today that said that by Carlucci, the guy who is bringing the bill, is a Democrat who has juice because he's doing this power sharing. He and 5 other Democrats are doing power sharing with Republicans in the state Senate. What Skelos said today, or yesterday, is that part of that power sharing is that he, Skelos, has reserved the right to keep any bill he wanted to from coming to the floor. So most people now think it's, it's going to be, whatever it is, showdown at the OK Corral, and it's more likely than not that it won't get to a vote. If it does, there are people on both sides of this issue who believe that there's no way Cuomo will sign it. The New York Post came out today, or yesterday, I guess, today, and and broke the story that Cuomo's not going to do anything until the election. But all of that said, yeah, if they did, subject to the thing I haven't told you yet, if they did a moratorium, then during the moratorium period, you'd have the time that you're talking about here to do road use or whatever. The one thing I want to say is that the press calls this a 2-year deal, but if you actually read what it says, it's the first to occur of 2 years, or when when Dr. Shaw, the health commissioner, is satisfied with respect to those studies, which doesn't necessarily mean when those studies are completed. It may be just executive summaries or whatever. But by the explicit terms of the Assembly's moratorium to which you make reference, it's not a flat 2 years. It's the first to occur of 2 years, or when those reports are done.
So you're not guaranteed 2 year time?
Correct.
Okay,
By the way, am I yelling? I've got new hearing aids and I can't tell. It sounds like I'm yelling.
It's good for me. I'm all right.
you mentioned compulsory integration with respect to the drilling part and the fracking part. But when we get into the other part of the pipelines, because all these wells that would be drilled and fracked are useless unless there's pipelines connecting them all. Now that would come under eminent domain, or where if you didn't want a pipeline through your property, they'd be able to do it anyway if they felt they had to, right?
Compulsory integration doesn't have anything to do with pipelines. Pipelines are regulated or addressed by, with reference to their size. So the big ones, the big fat ones, are regulated by the feds, the Federal Energy Regulatory Commission, FERC. And you have no say over that, just like you don't have any say over federal highways. The middle-sized ones are regulated by the state, PSC, Public Service Commission. And you have no say over those, just like you don't have any say over state highways. The tiny ones, the gathering ones, the ones that go from the wellhead to the middle-sized one, presently you do have say over. And you may address those, and I'm going to use the word regulate, you may address those with your local land use authority. You should be aware, we don't even, we typically don't even address those little pipelines anymore in our laws. We can if you want, but the PSC is taking the position, has said that they're looking at those. They figured out that if you kill the thing at or break it at the wellhead, there's no such thing as a medium one. So the PSC is talking about taking jurisdiction over the gathering lines, and everybody assumes they'll do that. But if you don't, if you don't have wells in your town to begin with, you don't need to worry about that, which is why we take them out of our law, because there's nothing to go, there's no wellhead to go to the middle-sized one. Sorry, Mike.
Yeah, maybe I misunderstood, sorry, I think your question was, does the landowner have anything to say about the place?
Right,
Not the municipality.
What he means is, if this one here, A says he can go through, B says he can't, C says he can, how do they get through the middle?
In the case of, they can't do anything with the gathering lines. In the case,
This is the gathering line I'm talking about.
they can't do anything. If it's a, if we're using gathering line the same way.
We can't do anything, the company, or
The people who want the pipeline, they can't, they've got
you
no.
can't force it on them?
They've got no power to go through PNC. But if it's a middle-sized one that the PSC regulates, or a large one that the FERC regulates, then they get basically a certificate of public convenience or whatever. That gives them a set, that allows them, that cloaks them with eminent domain power. Normally eminent domain power only exists in a governmental entity like you guys. But the middle-sized pipelines and that's how they do what they do. So they get their certificate of public convenience or whatever it's called. Then they go to the landowner who already said no to them. And they say, we know you said no, but now we have this, now we have the power of eminent domain. We don't want to have to use it, so we're going to ask you again. And then most of the time the landowners say okay, because they don't want to pay a lawyer to go through the eminent domain process. But yeah, even though you think that you have eminent domain and nobody else does, you know, only governments do, that's how they get those on the middle ones and the big ones.
Another question would be, as far as the pipelines, the compressor stations. Does the town or landowners have any say, I mean, once the wells are going in and the gas lines are going in, and the gas company says, hey, we gotta have 6 compressor stations in the township of McDonough to meet the needs, do we have any say to control that at all?
We address compressor stations in our laws, but it's important to realize that the compressor station for this purpose is a component. It's not literally, but the way we think of it, and it might help you to think about it, is that compressor stations are sort of a part of the pipeline. So if it's a pipeline that is regulated by the PSC, the middle-sized ones, or for the large ones, or I'm sorry, if the compressor station is attached to that, you probably don't have much say about it. You certainly don't have local land use authority.
So if the gas company made a case with a government agency that, hey, we need one here, pretty much it'd just be a rubber stamp and it would be, done.
I don't know much about how the state process works with the pipelines. I'm learning about the federal process, and the federal process pretty much admits that it's a rubber stamp. Because before it even gets, they have these, I went to a seminar that was basically for gas people. Luckily I look like Dick Cheney, so they let me in these places.
You said it, now I know.
And they admitted that, you know, basically, they go through these dog and pony shows, and I can't remember what the name of it is, where they rent a hotel, you know, room, and they give you some hors d'oeuvres, and they put some things up. But it's basically a done deal by them. If you do it the way FERC wants you to, it's a done deal. And they might move it here, a little bit here and there, but you don't have much say on a FERC
Now,
pipeline.
does the town have any jurisdiction over them on the noise ordinance for the compressor station?
My view is no. Basically, if you look at the cases here, remember I told you about, before you got here, I was telling you about the cases of the rock crusher. You know, if you're going to let the gravel mine people in, you can't say you can have gravel mine but not a rock crusher, because that's part and parcel of operations and processes. Clearly, things like setback requirements, 24/7 operations. In a perfect world, you guys don't have zoning, but in towns that have zoning, you would say, we're okay with this particular type of use, but we don't want you running your factory from, or the outside part of your factory from, whatever, 11 at night to 7 in the morning. There is case law that says you may not do that for gravel mining. You cannot tell them, you cannot restrict them to 11/7. So if you can't do it with gravel mining, every lawyer agrees you can't do it with gas mining. When you look at all of those, and we've read every single one of those cases, not that there are that many, but you know, there might be 15 or so. Our view is that you do not have the ability to regulate noise with respect to this particular area, even though there's a state, I don't know what 55 decibels sounds like, but even though there's state stuff that because that's part and parcel, the gas drilling industry's position is that for this thing to be economic, they must be allowed to work 24/7. So you know, if, we don't have it here, but in towns that would otherwise have, light restrictions at night, so I don't think you've got, the ability to use noise.
I have another question. It goes back to the Village of Oxford, when they passed their moratorium,
They didn't pass the moratorium, did you?
or, well, let's see, how,
Well, I'll
This
tell you
thing
what
where-
happened. They looked at a moratorium, and some people came in and said, if you pass a protective law, if you pass a protective law, we're gonna sue you. So this is from Marcellus Drilling News. And you can read it yourself. One of the largest landowner groups that MDN's aware of anywhere has promised, guaranteed a lawsuit against Oxford should the village move forward with language that results in a ban and moratorium. And at the same time, what this was picking up was that this same coalition basically went statewide with a plea for funds so that it could, they'd have money in the bank and then they could go to Roger's client and say, if you pass one of these laws, we're going to sue you. And they promised to sue.
that sounds like extortion to me.
That, well, as I said, out of the hundreds, over 100 times, I've heard people pound the table and say they're going to sue. 100 times I've heard them say, in fact, here's a lawsuit here, you can look at it. And it doesn't, you know, I don't want to bait anybody into doing anything. As a matter of fact, what that group did afterwards, so the village didn't do a moratorium, they did a zoning amendment. And when that was over, what these groups said is, they basically said, we're not going to sue. They never really said that, but they obviously weren't. But they said, but we learned a lot, and if we wanted to attack the village's law, we could. We know how to do it, but we're not going to bother because it's, quote, low-hanging fruit. Now, maybe that's why they're not doing it. I don't know.
What is stronger, an amendment or a moratorium?
You mean a moratorium or a ban?
No, amendment to the zoning law or a moratorium?
Well, the village had a zoning ordinance, so they
Right.
could do it, and here you don't have that.
Right,
opportunity.
but in that case, what is stronger, a zoning ordinance amendment or a moratorium?
We can make them, well, you're asking Ron.
Well, I'm
I think-
asking
I
who
think-
wants to answer it.
You can,
I think they're on the same footing.
yeah.
I really think it depends what the court of appeals does.
And we can make one just as strong as the other. We can make one bulletproof, and if you don't want one bulletproof, if you want to leave a little, we can make either of them, well, people, for their reasons to do that sometimes.
Well, where my question was going was, like, Oxford has the zoning. And my understanding is, once they made a decision, then it goes up to the county planning board. It has to get approval by them.
An amendment to any zoning ordinance, okay, in this particular case, since it affected property, certain types of property, near the village boundaries, highways, etc., got put up to the county planning board.
Okay,
And
now,
that's required
we
by
have
law.
no plan, or no zoning,
That's
so we
correct.
wouldn't have to have it go before the
Yes, you
county.
would.
We would.
What the law that Roger's talking about is General Municipal Law, GML 239M, as in Monaco. Because there's also L and N that sometimes are implicated here. And what that says is that if you're doing something, as Roger alluded to, that affects nearby property, a whole number of things have to come in. If they're basically land use issues, they have to go to the county planning board.
Now, when you
for
say
review.
nearby, you mean like the town of German, the town of Preston?
Yes, other municipalities,
Other municipalities?
waterways, highways, I think.
In this case, the moratorium, if we did the moratorium, and if it was a moratorium, unlike the Binghamton moratorium, but what we're talking about here is a moratorium, we always send the moratoriums for 239M review as well. Now, the way that process works is that even if it's a moratorium, not a zoning amendment, is what I'm trying to say. And the way that process works is that the county planning people have essentially 30 days. There's some exceptions, but they essentially have 30 days to look at that. They don't have the right to veto or prohibit you from doing what you're doing. And they're only allowed, their jurisdiction is limited to two areas, county-wide impacts and intra-community impacts. In other words, things that, so in those two areas, those are the only things that they may legally appropriately look at. They, as I said, they may not veto you, but if they don't, if they have an objection or they want to change that you don't want, then instead of being able to pass your law with 3 votes, you need 4 votes.
You need a supermajority. They call it supermajority.
And when it comes back, it's gonna have 4.
So another question I would have is, if this town has a moratorium, and if it ever did go down the road where it ended up with a ban, we're surrounded by what, four townships. If the other townships allowed fracking and they had wells just over the town boundary, would they legally be able to, frack back under the town of McDonough
Now
to somebody who they have a lease with?
Now we're back into compulsory integration. And we don't think so. And I don't want to go into why I'm equivocating, because I'm in mixed company here. But I can talk to you another. In my mind, that's a reason to have a protected law as opposed to not, some people might say, well, they're doing it around us, we might as well let them in here too, but I'd say that's more reason to have protection in your town.
Well, I've seen in the regulations online where they've got it worded that the state will not allow any surface disturbance on state land, or the drilling and all of that, but they will allow subsurface disturbance, which that tells me if they have a well on private land, they can drill as far under state land as they want, and
Right, and we have no authority here, as I'm sure you know. We have no authority with your land use law, moratorium, or otherwise to deal with state land, just like it's like dealing with the state highway. But yeah, you're right.
So even if we had a moratorium and they allowed gas drilling, they could come in and drill on state land,
no.
if they would allow it.
The law, we have to assume the law can change, but as you just mentioned, under the, as presently contemplated, the only thing that's going to be allowed, if anything, is subsurface. But yeah, you couldn't prevent it. You can't tell them what to do when they're.
I'm just saying, if they did change it.
Yeah.
Or if there was state land bordering another town that allowed fracking, they could frack on the state land.
Yeah, I mean, it doesn't matter where it is. The point is that if it's state land, you have no authority over it, just like you don't over the state highway.
And what you presented tonight, you will make available
Yeah, just,
online?
all I need is, I guess I'll send it to you and then you'll make it.
Well, if one of us gets it, we can get it printed out for anybody who doesn't have.
I'm gonna send it to the clerk, so.
Oh, okay, because
Now, if we decide to go ahead with a moratorium, how long does it take to get that whole thing processed?
He'll have it to you the next day.
Yeah.
Oh, yeah.
Unlike a zoning amendment, which is a lot of legal time, lawyer time, there's not a lot of lawyer time on this. You could get the process done, if you were fast tracking it, 45 days, but certainly 60 days comfortably. Because this would be like any other local law, which would mean you'd have to have a public hearing and so forth.
That's right.
But you can run that public hearing period concurrently with the 30-day period through that you've got with county planning under 239M. So that's really your outside date. And then when people are, if they're really trying to get it done, people will say, well, we're not having another meeting until next whatever. You just want to keep in mind, if that's what you're trying to do, you can always have a special meeting anytime you want.
Posted 72 hours ahead.
Right.
I have a question. If I remember correctly, as you were going through that, when it comes to like the waste disposal, the way it's currently set up, if we allowed the whole process to come here, we really have no say then as far as what that would all be under the DEC regulations of what they do with their waste, how they do their waste, where they put their waste.
You read, and as I said, I wasn't familiar with it, but there are all kinds of provisions of the law that allow somebody, a municipality, to enact laws that are more stringent than the state law. One of those areas is solid waste disposal. And in fact, our law does that. We specifically reference that, and we could definitely, and we do in our law, deal with the waste issue. We think that that's really important, even in places that don't anticipate a lot of drilling per se. The waste stream here can be pretty serious.
Right, and this town had the Novak farm.
I'm not familiar with
Well, that was, I don't know, it's industrial solvents, I believe it was, that were brought up, were they brought from Syracuse or New Jersey, I really can't remember.
Solvent saver.
Yeah, they buried them on a farm, about a mile and a half or 2 miles from here. And,
United States
they
Air
had a
Force,
big
Bristol
cleanup.
Myers.
Pardon?
The United States Air Force, Bristol Myers, and another bunch of, well-deserved.
Solid citizens?
Well-deserved
Yeah.
companies
Yeah.
up in Syracuse hired this company by the name of Solvent Savers. They had another one over in Lincoln, which is in Shenango
So-
County as well.
I mean, the town is familiar with being a dump site.
We spend a lot of time on the substance of the areas that our law covers. We spend more time on the solid waste issues than the drilling.
So in other words, your law can control this solid waste?
We can't keep them from dumping it illegally, but of course, but what we can make it illegal to have that stuff in this town, even if it is otherwise specifically accepted or exempted from various hazardous waste laws. So the difference is if they store it here or if they spill it here, they're gonna tell you it's not hazardous. And so you're gonna have, good for him, but you're gonna be paying lawyers to have a fight over, because they're gonna say they're exempt, and they are. And I think you win that on appeal. I'm pretty sure you lose it down below at the first level. If you have this law, you'll win at the first level, because of the way we define it. Again, I don't think I have one, but I might have one on my machine. We literally spend more pages on this issue than on drilling, because this is where we see the risk.
The other thing with this whole subject that has troubled me immensely is this non-disclosure agreement. Where the gas industry presents basically, there are no problems here, there are no recorded incidences, blah, blah, blah. And where so many times it's, well, yeah, there was an incident, but the people have agreed to, in order to get the check to compensate them, have had to sign a non-disclosure agreement. And, that wouldn't be a moratorium thing, but that's, I just find that troubling to where, to basically cover your tracks and make everything look like there is no problem here, nothing to see here, just keep moving along.
It's not an uncommon practice in the business world, in the world of litigation with industry. But where I think it's important to recognize it is the fact that it really does go to the heart of the claims that there's never ever in the history of the world been a spill of fracking fluid or something. I mean, common sense tells you that's not true. And if you drive by and you see people with water buffaloes on their property, and you knock on the door and they won't tell you anything about it, so. But you're right, that's not an issue for me, for the moratorium.
Anybody else on the board, any questions for us, gentlemen?
I just thank you for accepting our invitation and
Thank you for having me,
coming
sincerely.
over and presenting your presentation.
Thank you.
And
Roger, I'm sorry for sitting in your chair.
Well,
If anybody has any questions or need anything, I'm actually gonna wait back there.
Okay.
But thank you very much for having me.
agenda is Mr. Lottje. I might not pronounce his name.
Correct.
He's gonna give us a presentation to the board.
I don't have
The other side
a
of the
projection
line.
system. Brian Lattrette, I represent the Shenango Central New York Landowners Coalition on behalf of landowners here in McDonough. I don't have a projector or anything to present. What I do have is another position that's a resolution that pretty much states, and you can read it over here, I'll hand it out, to take a position of sticking with New York State instead of coming up with your own rules and regulations.
I'm sorry, I'll just pass them out. I can get you more too. I'll email it to you.
One thing I'd like to say here, I heard someone say that pipelines won't be an issue because what you're in effect looking to do is ban natural gas drilling in McDonough. That's, again, that's some touchy ground. I also heard that there was the lawsuit in Oxford wasn't really serious from its sounds, from what was presented to you tonight. Roger knows, I think, it was very serious. And Brian Conover, the head of the coalition, will tell you, it was very serious, okay? The town is the one that chose to step down. We didn't choose to step back. I want you to know that right up front. Okay, the other thing I'd like to point out tonight is I also heard that there's fewer than 5 attorneys that disagree with your presenter. Well, there's only one attorney that's presenting any moratoriums. Okay? And we have to look at that attorney, who he's presenting for and who funds him. Our boards are supposed to be non-biased. Okay? And what we have tonight presenting is a biased agenda, supported by a biased agenda. If we follow where the money comes from this biased agenda, you'll find that it comes from Earth Justice. Because when I say it comes from Earth Justice, it says there's a firm that's willing to stand behind us that has 200 to 300 people. And they'll do this for free.
What are you?
Okay? I don't know anybody that does anything for free in the attorney field. So somebody is funding somebody from somewhere. The board, again, is to remain unbiased, to look at the situation that you're in. And when you have one-side agenda willing to promise you the world for free, I think I'd be very concerned with that. Okay, again, as a representative for the landowners tonight, we will be paying close attention to this, as it affects our properties. So again, I thank you very much for your time. As I said, I would only take up a few minutes. I'd like you to look over the resolution and take into consideration the impacts it has on our area, on adjacent town, and the future to our area, that I think our hands are in the states at this time, with a possibility of an additional 2-year moratorium. During that moratorium, you have to decide what it is you're going to be working on. A huge amount of work that this board is going to be pushed to. They can present something to you in a matter of days, as Roger knows, okay? But it's also up to you to follow it and start changing some of the regulations within your town. The county has road use agreements, okay, which, again, if this does take place, I think it's best for your truck traffic to all understand the same rules and regulations as they go from town to town. And you can control noise ordinance, okay? Again, it is through zoning, but I look into the town of Windsor, who has done that. They have an operating compressor station there. So, again, thank you very much for your time.
What do I advise you to do?
You gotta earn your money.
I think, you know, to me, you look at it, and there's environmental hazards that are obvious, and there's economic benefits that are just as obvious. I mean, you've got a tough decision. But I wasn't elected, you know, I'm not trying to pass the buck. You know, you folks were, it's a tough decision.
You just happen to live in the town.
I just happen to live in town. I mean, there's obvious, I mean, there are gonna be spills someplace, you know, it's gonna happen. No matter how careful they are, there's gonna be an accident someplace. I'm sure the industry doesn't like that. I don't paint them with a black brush as David does, but it's gonna happen. but just as surely, I mean, the economic benefits, not only for landowners, but also, you know, the workers that'll come here, I mean, to me, are just as obvious. So you've got a tough decision, but I'm not gonna make it for you. My job is, whatever you decide to do, is to implement that decision.
We're gonna have to take time to digest this a little bit. There'll be no questions after the meeting. We have to have the regular town board meeting now. Thank you.
Sure. Go ahead, and road use and, town of the school, or you want to discuss that?
We want to discuss the school part.
Up to you.
Well, there's one here, we have the letter. Before he goes, he wants to tell us about our deal with the school bus garage.
I think I sent you some material on it. Basically, they're ready to go. It turns out, that the deed was never filed originally. When the town gave the garage to the school, that deed was never filed. They're gonna give us a deed anyway. It's gotta go in front of the school vote since it's giving away school property, correct? My concern over the issue is, again, are there any environmental problems here that the town has inherited? Was the school dumping oil or other hazardous materials on that property? You know, if that's the case, you really don't wanna take official title to the property. But otherwise, if it's something that we need for town purposes, let me know, we can effectuate it. Yeah, is that true?
We don't know of any fuel tanks that were there, do we? Did they ever store diesel for the buses there?
I mean, would they have changed oil or dumped any, you know?
I don't believe, because all it
It
was
was just
storage.
storage, not
The storage?
Right.
That's all they did is store two buses. Donnie, they never, as far as you know, they never did any service work on the buses in there, did they?
Years ago, they done, little, I mean, not the major stuff, if they had to come up here and fix something to get it going, that is about, nothing to the extent of, draining oils and all that. And the only oil thing you'd have to worry about, was probably the furnace that they had in there, and that's all out now, and the tank is too.
The building was originally built for the buses, I mean,
School,
now
I
somebody had a
think.
garage there years
The
ago.
town gave that to the school to build bus garage,
Okay,
is what I understood.
I don't know, it's before my time here.
I guess there's a contract, you know, they want you to sign. Basically, it's, I think, $1.
Yeah.
I mean, there's no cost involved. If you want to proceed, I need that contract signed and get it back to the school.
Did you send me a contract?
I'll send it over.
Okay. No, I have it. I'll call you. Okay.
Anything else you know?
That's it, I guess. Okay, thank you.
Right on.
I'm not leaving, you can go right ahead.
So we've had the presentations, now we're gonna resume the regular meeting. Clerk, please read the minutes from the last meeting.
Public hearing on the right to farm law and regular meeting of the town board, Monday, February 11th, 2013. The public hearing was called to order by Supervisor Canor. Present were Councilman Tracy, Councilman Barrows, Councilwoman Beckwith, Councilman Harvey, Superintendent Haas. Supervisor Canor asked if there were any questions from the public. With no questions, a motion to close the public hearing was made by Councilman Tracy and seconded by Councilwoman Beckwith. All in favor, motion carried. Regular town board meeting was called to order by Supervisor Canor. The board led the Pledge of Allegiance. Clerk read the minutes from the January 14th meeting. The motion to accept as read was made by Councilman Tracy and seconded by Councilman Barrows. All in favor, motion carried. Supervisor's financial report was read. A motion to accept as read was made by Councilman Barrows and seconded by Councilman Tracy. All in favor, motion carried. Highway warrants read, vouchers 17 through 27 totaling $9,506.53. General warrants read, vouchers 17 through 34 totaling $8,900. $168.45, and prepaid warrants and red vouchers 10 through 20 totaling $3,232.84. A motion to pay all warrants as read was made by Councilman Tracy and seconded by Councilman Harvey. All in favor, motion carried. Highway report, Superintendent Haas reported that he had calculated the cost to maintain roads to be $18 to $20 per mile. Superintendent Haas reported that he met with the Chenango County Sheriff's Office regarding our road use law. He was informed that they will not enforce the law. They referred us to our town attorney to bring a civil case for recouping our money. New York State DEC has reworded their contracts going forward, stating a bond amount shall be determined by the town. Superintendent Haas passed a spec sheet on a roller to the board members for their review. Delta Engineering will be giving a presentation to the board members tomorrow, February 12th, on how they do their road program. Old Business Resolution 2013-4, Supervisor Arrington J. Canora offers the following resolution for adoption. Whereas a local law being proposed, local law number 1 of the year 2013, which is attached here to the right to farm law, is introduced again at this February 11th, 2013 meeting for a public hearing and to adopt this local law. Seconded by Councilman Tracy. Roll call, 5 in favor, 0 opposed, 0 absent. Motion carried. Resolution 2013-5, Supervisor Arrington J. Canora offers the following resolution for adoption. Whereas the Oxford Central School District wants to transfer back to the town of McDonough the Oxford Central School District Bus Garage, deed transfer. Purchase price is $0. Location of property and school bus garage is next to the town park on State Route 220, McDonough, New York. Seconded by Councilman Tracy. Roll call, 5 in favor, 0 opposed, 0 absent. Motion carried. Supervisor Canora read a notice he received from the CNY Landowners Coalition. Discussion took place regarding lawyer Slottje coming to a town board meeting to address questions regarding gas drilling. Councilman Tracy made a motion to have Supervisor Canora contact Mr. Slottje and ask for a special meeting to address our board. Seconded by Councilman Harvey. All in favor, motion carried. New business, Ms. Kelly Brannigan from the town of Middlefield in Otsego County addressed our board describing actions taken by their town with regard to gas drilling. The town of Middlefield does have a zoning master plan, zoning laws designed to preserve the character of their town, and a planning board in place. Ms. Brannigan urged our board to bring forth a moratorium which would stop all activity regarding gas drilling until the town can prepare how to go forward. Councilman Harvey made a motion that when Supervisor Canora speaks with Attorney Slottje, that he ask him to be prepared to present to our board what is involved in a moratorium, so a vote can be taken whether to go forward at the next meeting. Seconded by Councilman Barrows. Roll call, 5 in favor, 0 opposed, 0 absent. Motion carried. Councilman Harvey made a motion to adjourn, seconded by Councilman Barrows. All in favor, motion carried. Respectfully submitted, Donna Preston, Town Clerk.
Is there any additions or corrections to the minutes?
Yeah, I was given a note by our highway superintendent, under the highway report, the $18 to $20 per mile, should have some kind of a note with it, that is winter maintenance, sand and, snow removal, sand.
Yeah, I thought it was too.
Winter maintenance,
Yeah,
is that?
winter road clearing.
That was per storm, right?
Yes.
Or per occurrence?
Per
occurrence.
Or food trip.
Anybody else have anything on it? Okay,
Make a motion, accept the minutes as read.
I'll second.
all in favor? Okay, now read the supervisor's report. In general, the beginning balance, $106,515.95. Total revenue is $91,093.03. Total disbursements is $13,019.29, leaving ending balance of $184,589.69. In the highway, the beginning balance is $167,436.18. Total revenue is $274,063.99. Total disbursements, $17,241.33, leaving ending balance of $424,258.84. Capital reserve machinery, beginning balance, $200,270.99. Total revenue, $7.45. Total disbursements, $1,890. Leaving ending balance of $198,388.44. Capital reserve unemployed, beginning balance is $14,912.97. Total revenue is 34 cents. Zero disbursements, leaving ending balance of $14,913.31. Highway building maintenance, beginning balance $19,747.61. Total revenue 44 cents. Zero disbursements, leaving ending balance of $19,747.60. The capital reserve Emory Harrow, beginning balance $8,039.28. Total revenue is 69 cents. Total disbursements is 300, leaving ending balance of $7,739.97. That's $100,000 CD. Capital reserve town hall, beginning balance $12,551.59. Total revenue 28 cents. Zero disbursements, leaving ending balance of $12,551.87. Anybody got any questions?
I have a comment, just so the public knows. Under the general fund, where it says a total revenue of $91,000, 60+ thousand of that came from real estate taxes, 30+ thousand came from sales tax, and then over there under highway, showing a revenue of $274,000. Everything but $14 of that was real estate taxes coming in. So we haven't found a bank yet that'll pay that kind of interest, so you have to keep paying your taxes.
That's where the 69 cents and the 44 cents.
Yeah.
Anybody else got anything?
You don't have to pay your taxes.
Well, that's true,
The
too.
county's gotta pay us that much anyway. So I'll make a motion to accept the financial report.
Any second on it?
I'll second it.
All in favor?
Aye.
Can the clerk please read the bill for us?
Highway warrant, March 11th, 2013, beginning claim number 28. Gillies Auto Truck, $236.37. John's Garage, $955.86. McKee Equipment, $135.78. Reese Marshall, $1,478.14. Steel Sales, $189. Tom Haas, $27.79. And Tri-County Communications, $99.75. Total highway warrant, $3,122.69. General warrant, beginning claim number 35, Art Canor, $69.58. Donna Preston, $220.27. Evening Sun, $26.72. Harding Brooks Associates, $15,444.26. Hayes Office Products, $12.49. Nelson Lucier, $234.24. Noble Industrial Supply, $269.65. Reese Marshall, $2,154.06. Roger Monaco, $580. Roxanna Harvey, $399.49.49. Woolly Bear Webb, $99. Total general warrant, $19,558.76. Prepaid warrants, beginning claim number 21, Donna Preston, $100. Frontier, $48.07, $121.32, and $255.50. New York State Teamsters Council, $194.22, and $2,054.98. NYSEG, $18.33, $50.59, and $442.42. Total prepaid warrant, $3,285.43.
Any questions on the business?
Huh? Make a motion to pay the warrants.
I'll second.
All in favor?
All right, first thing is, I'm hoping the winter's about done. One thing I wanna make everybody aware of is if we do get snow now, you're probably not going to see a whole lot of plowing on the roads, and I shouldn't have to answer why. If you've been on any of the dirt roads, they are soft, very, very soft. We drop a plow on one of those roads, we're gonna not go anywhere, number one, and dig a hole in the road. But if we get significant enough snow where we have to plow them, we're gonna do our best to plow them and, you know, keep them clear. One of the things I would like to say now that the winter's come to an end, two of the workers I have, which are Terry and Doug, the only two workers I have at this time, they've done a fabulous job through the winter, canceling family functions, canceling a lot. Doctor's appointments when there's been a snowstorm. They've been there at my beck and call without a problem, and I think they've done a very good job. We've put in some very long hours, and I've got to thank them publicly for that. There's been absolutely no issue with them at all. We've got some couple big road projects this year planned. One of them's going to be Tice Road, and there's going to be a couple projects done on a couple other roads. One of them Creek Road. Strong Road, we have a 4-foot pipe to put in up there, so as soon as this weather breaks, we're going to be pretty busy. March 6th in Albany, not all the highway superintendents, a lot of the highway superintendents from across the state went up for Amnesty Day, and it's with the CHIPS program, the money we get from the state. We haven't had a raise in the CHIPS money for roughly 5 years, and as everybody knows, fuel costs have sucked up probably 80% of the CHIPS money from the state. The Highway Superintendent's Coalition asked for a $100 million raise across the state with the CHIPS money. Presently, we get $109,000 a year. However, they divide the $100 million up, we would get a raise. It wouldn't be that substantial, but it would be something more than we're getting now. And on another note, like I brought up last time, a roller in the packet I just passed out is the roller. I've gone down to Beck Equipment, negotiated with them. That's one of the necessities when you have dirt roads, is to have a roller. The price of the roller started out at $63,000. I negotiated with them, got them down to $56,000 in a couple different scenarios that you see in front of you. Scenario 1 would be a 4-month rental purchase, as it says, with 80% going towards the lease of it, which would knock off the price. That would come with a 180-day warranty and 100% powertrain. Scenario 1 would be $3,300 a month for only 3 months is all they'll allow, with 100% going towards the purchase price. Scenario 2. Did I say 3?
Yeah, I said 1.
Oh. Scenario 2.
Say what? I heard it.
Uh,
Which one are we on here?
2.
Okay.
2. No, there's no 3. So that's what we're looking at, right there. And that's, scenario 2 only comes with a 90-day warranty, which would be the 3-month of the lease with the purchase. Scenario 2 does 2 things. It gives us an additional 90-day powertrain, and it also gives us a less of a purchase price at the end.
Number 1 or number 2?
Number 1, I'm sorry.
So we're gonna rent it for, number 1 is a 4-month lease.
Correct.
Let me ask you this here, number 1 scenario. if we enter into that agreement and after, say, 3 months, you determine, dude, this thing is a real lemon, we don't want this, it's nothing but trouble, are we able to get out of this thing then and just say, hey, thank you for the 3 months rental?
Absolutely, yes,
Okay.
yes.
But we have to tell them up front. We can't just rent it for 3 months and say, yeah, we wanna do the
No,
use there. We gotta let them know up front.
we gotta let them know up
This
front.
is what we're gonna do.
Correct, absolutely correct, yes. And Beck Equipment's been around for quite some time. The town does have a good history with Beck Equipment. And if something major was to go wrong with the roller after the 180-day warranty, say the engine blew or the vibrator went out of it, we try to reach an agreement where we pay the parts, they pay the labor. If we can't come to that type of agreement, they'll deduct what the state rate is per hour of a roller. They'll deduct that from the purchase price and buy the roller back from it.
Run that by state rate per hour that we used it?
That we used it, they would deduct that from what we paid
The
for
state
it.
rate is when you're doing your chip job.
Correct.
Which is only fair if we use the roller for 6 months and
Then the transmission goes on it, and we don't wanna reach an agreement to fix it.
we still got the 6 months.
Correct.
And that would be in writing in the agreement?
That, yeah, it's sketchy in the writing, but after talking to a couple, it's there. But after talking to a couple of the towns that deal with them, they've stood behind everything that they've done.
They've never done us wrong anything we bought. from
No,
them, so.
they've been very good with it.
Now, that would have to go, out for bid.
That, yes, that would have to go out for bid unless there was, according to what I read in the book for bidding, unless the town board makes a I'm gonna prepare to put this out for bid, but unless the town board makes a resolution to purchase it with no bidding.
I think we're better off to put it out to bid.
Less hassle.
Oh, yeah, a lot less. Now, before you go too far, if you go to the next page underneath that, I've been looking, for quite some time for another truck. Right now, Terry's truck, the 93, that we just had the engine rebuilt, broke down a week and a half ago. God bless you.
Thank you.
Broke down a week and a half ago. That is down to Wynn's Garage right now. There's serious electrical problems with it. They're trying to get to the bottom of it. John's Garage came up here 2 different days. We got it running enough to get it back to the shop. They worked on it in the shop, could not get it figured out. It was just idling one day as we were putting sand in it, and it quit. We got it running, we made it halfway up Creek Road, it quit. We finally got it back to the shop, and that seems to be a problem. We put the Ford back on, brought that up online, which everything in that is good. Also, John's got it over there, the truck is starting to smoke quite a bit, and they believe the rings from that engine job never seated properly. So once we get the electrical fixed so it'll run, it's gonna have to go back to Dixon Diesel to have them look at it. As you see in front of you there with this 96 Volvo, the town of Marathon has that. The truck is in exceptional shape, as everything there states. I've looked at 2002s, 2008s. They're quite a ways up there in price. I looked at a 2000 Mac, which is a nice truck, but it's also $43,000. Now, one of the things with purchasing a new truck or getting a newer truck, down the town of Oxford, they've got two newer trucks, both of them went out on a flatbed on Friday with emissions and computer problems. And the town of Marathon's got a new truck that they're already up to number 4 crankshaft in the new truck. Yeah.
This is a 96 you're talking about.
Yeah, this is a 96 here.
All right.
And that's, one of the problems you have with the new trucks is the emissions and the computers. I've talked to Doug down to Reese Marshall, and he's got a couple new vehicles in there, and they're having problems with the emissions also, with keeping them running.
What do you want to say? 27,000.
That's what they're asking for, and if you go down through what I would offer them, I'd like to make them an offer 18,000 for it. We went down, like I said, we went through the whole truck, we took it out for a test drive, it's got all brand new tires on it. The
So
only,
you're looking at 7,000 difference here, from what they want and to what you want.
yeah,
Now, what brand new tires cost you how much?
brand new tires are gonna be about $2 grand, it's got all brand new tires on it, this truck does.
Yeah, I mean, you can buy 10 tires for 2,000?
Yeah, well, that's what's on there,
I know.
brand new
You
ones.
got
Yeah.
it.
Well, they wouldn't be all brand new, they'd be recaps on the back and brand new on the front.
So say for, this truck has all brand new tires.
Yes.
So what I'm trying to say is, if you had to put tires on your truck, how much would it cost you for all brand new tires?
All brand new without recaps?
Yeah,
You're talking about $50,000 or $5,000.
okay, so there's your 5 here, why don't you give them the 25 and get the truck?
Because I think it's too much.
It's not really.
Honestly.
It's not really, if that truck is true to what you say.
Oh, it is, believe me, it is.
I think if we can talk them down a little more.
Well, you can try it.
Better off doing it.
What, did he call you?
No.
We're.
You old for it?
17 years old.
Oh, I know. I
Yeah.
understand that.
Yeah,
But then you go below that, then the board has to
No,
pass it,
no, no.
right?
that's what they want for it.
What's that?
So if you say you're 18,000, then the board has to pass it for you to get the truck, right?
Yeah.
Yeah, the board has to okay that. But the board seems to be comfortable with 25, huh? Okay, well.
No.
The board down
Not
there.
this-
Well,
not this
what my thing was is offering
Their
me,
board is comfortable with it, not you,
is
I know.
offering them 18,000 and then going as high as 21.5. I mean,
Yeah,
you
you can
know,
try that, yeah.
What you're thinking is you would go to their board meeting.
no, their board meeting's tomorrow night, and talking to Randy, he said, just call me with the offer. He said they know the price is a little high on that. You know, I found a comparable today, I found a 2001 tandem Volvo. It had 172,000 miles on it, no plows, no sander, and it needed 10 tires. And that was $28,000. So right there, you're back up to $35,000 for, you know, a 2001.
This does have a sander with it.
This has got a sander with it,
A
yes.
slide-in sander? or-
Slide-in,
Okay.
slide-in box sander. It
Stainless or?
no, it's not,
Okay.
not the big kind. It's,
Oh, okay.
it goes right in the gate,
Yep.
right in the coal chute,
Yep.
and it's got the drop right in the middle, right in the
Okay.
center, which are the, that's what towns are starting to go to now, so they get away with this, get away from the slide-in.
This is all set up for snow plow, it's got the snow plow with it.
He's got the snow
Right there,
plow, the
11
wings
foot
with
plow
it,
and an 11-foot wing.
with the carbide, it's got carbide edges on it, which we don't use, but,
Would we pay 14,000 for a brand new box on that one truck, right,
yes.
Yeah.
last year, and if it
And
even has a
Why
box?
are they getting rid of it?
they bought they've got a brand new Western Star and a brand new, well, a 2007 Volvo. And when the Volvo went down with the cranks, they use this truck.
I can't remember what the, or either we bought our grader from them, or they bought our old grader, I can't remember which way it
They
went.
want our old.
They bought our old grader, that's right. When we repaid the favor.
Yeah, well, how good was the old grader?
I don't know, I think they used it for quite a while.
Okay.
Yeah, they're not bad.
I don't think they're mad, so.
But, like I said, I've looked, we've been looking quite a few places.
So you were talking about offering them 18-something, go as high as 21.5? I would say, offer them what you're talking about, the 18, but maybe go up to, say, 22, and see where they'll do it for that.
And we can take the 93 and advertise that and get what we can get.
Correct. And surplus that, absolutely, because that's.
Now, that's the one that had the engine job and is smoking, and
Yeah.
we've had a lot of problems with it.
Yeah.
so.
And Kurt's, just with this one also, Kurt's just got done putting a whole new floor in this box. The box was sandblasted. I mean, it's been kept up. I mean, the two, Terry and Doug couldn't believe how clean it was.
And you don't need one to bid on that.
Because we're buying from another municipality, we don't have to worry about bidding credits. I'll make a motion that Tom makes him an offer starting at the 18, and I think I would go up to like 23. I'll say 23, just to be safe.
I'll second it.
Any more discussion on it before we vote?
If I get it under 23, do I get to keep the?
As long as you split it.
We have a motion and a second, and no more discussion on it. All in favor?
Aye.
Aye.
Okay.
What do you feel about the roller?
Well, let's get it run for bid.
Well, during that 3-month time,
No, 3 months.
the 4-month time, I can put it out to bid.
Yeah.
And the bid price would be our price, which would be $45,000.
Marathon don't have roll over there,
No.
Well, we need a roller. I mean, every year we run a roller.
Well, and he's down to we're down to a more affordable price than the 63 grand.
And we send the roller back at the end of 6 months, and what do we got?
Right,
Just
well,
a lot less money in our pocket.
right,
so.
well, on the bottom, the roller would cost us, if we keep renting a roller, it's gonna cost us $19,800 a year to rent a roller. In 2 years, 2.5 years, you'd have this,
We paid for it.
you'd pay for it, correct.
And quite a bit of this, you can do under chips anyway.
Right, yeah, every time that roller's being used on a road, it gets charged in chips.
What's the hourly rate for it?
Hourly rate 62, I think it's 62.98 for a roller. A truck, a 10-wheeler, $75 an hour plus your man to run it. The roller would be the same thing with the man to run it, which that's $25 an hour for the man to run it, because you take his hourly wage plus his benefit package that he gets.
You're gonna get pretty good on it, gonna be quite a payback the first year.
Oh, yeah.
I'll make a motion that we rent the roller for the 4 months, and the next month, if Tom can have specs for us to go out to bid,
Okay.
we can get it advertised
Yep.
and have the bid opening the following,
And that's under scenario number 1, right?
yeah.
Yeah.
Which will make bid openings March or May, the May meeting, right? Is it March meeting?
It would be, bid openings would probably be,
If you can get the specs to us next meeting,
bid openings would be in July, probably.
they don't have to be though.
No.
I'm just saying, if we get it done and over with, if you get the specs to us for the next meeting, we can put it out to bid, and we can open the bids the
Okay.
following meeting. So March, April, we can open in the May meeting.
May, okay.
So you made the motion. I'll second it.
Any more discussion on that? favor?
Aye.
What else you got for us? Anything?
That's it.
That's it? Okay, I
So,
mean,
Paul,
go ahead.
do you plan to, do any hole patching?
Yeah, once we get some, good weather.
Just had to put that in there. Cause
Well,
Pike Road's getting awful rough. You gotta drive on the other side of the road half
As
the way.
soon as it dries out, we're gonna start grading them. I mean, you know, we're gonna go through and grade them as soon as it dries out.
I figured you would.
Oh, yeah, Terry's got his grader already, he's even warming the handles up.
Now, under old business, what about Delta Engineering here? Now, here's how I feel about it. They got a law, what they were supposed to tell us, they had a law, and, what else did they have? Something else they were supposed to, but they never showed us the thing, so we're kinda like buying a pig in a poke for that money.
Don't follow you.
Well, they had what you was there, but they had a law and something else, I don't know what it was. And for $10,000,
They normally have a law and an agreement, and the engineer, the road initial engineer for that.
oh yeah, that's right, then. Well, personally myself, I don't feel it's worth it for $10,000. I think better off put $10,000 to use this truck or the road.
Well, the big thing with the road use law, which I'm running into right now, I've got, you know, the people that are using the roads with heavy equipment right now is they are stopping use after I got a hold of a few of them. But they are contacting me, but the big thing is, again, with the enforcement end of it.
Now,
I
we
mean-
got the lawyer here, excuse me one
Go
minute.
ahead.
But under this here, when they post a road, that's under state law, right? It says right on the sign. Now, under state law, doesn't the state trooper have to enforce that?
I don't know the answer, I heard earlier, I mean, it is the vehicle and traffic law,
It's a vehicle traffic law.
but, you know, there are a lot of things, if you call them, if you tell them that there's a kid making noise at your house, and, or outside your house, and you've got something else going on, they just don't show up to your house, you know, they prioritize, so it's, I don't know the answer, I can get the answer for you.
Call the county.
We already know the stance on the
We
town.
already know
Yeah,
what-
I've met with the sheriff's department, and they said, take it up with your town attorney, he can sue them civilly to recoup the money of the damages of the road. We're not gonna come out there and chase log trucks around, giving them tickets for driving too heavy on a road.
What's the difference between that and speeding now, right? I'll get you an answer.
Just call and say there's a log truck speeding down there. It's the opposite.
And they've been doing a lot of that with people with cell phones anymore. The thing is though, you have to sign a statement.
Who said this, the state police or the county sheriff?
County sheriff.
Okay, back to Delta here now.
But anyway, to get back to what I was saying, it's gonna be the enforcement end of it. Just like when you had called me Saturday evening with what you saw was going, well, I can't be out there on the roads all the time, and I know you guys all understand that. So if something's going on, you know, and a sheriff's department drives by a log truck loading logs on a road that's posted, he's just gonna keep driving by.
That's right.
Or, you know, same thing for a state trooper. I mean, that's why a couple of the log companies have been over at our neighboring town, have been getting logs out at night when nobody's around. They've been taking, because their superintendent has told them, don't use the roads, they're too soft. But at night, they come in there, and then in the morning, he goes by and a load of logs is missing.
Yeah, so you really can't enforce it. Well, that's my personal opinion on the Delta. I don't feel we should spend, that's my opinion, the $10,000. I think you better put it in one of these machines.
As I remember back to the meeting, they did not take core samples, right?
Nope, don't do that anymore.
And if we needed traffic counters, we had to get those, was
Yep,
it?
they
No,
do that either.
we didn't have to. It was $1,000 less if we did. Is that what they told us?
Yes,
Okay.
but we could do our own traffic counters if we wanted to
It was
by getting them from the
$1,000 less
county
if
or,
we did the traffic.
correct, or a town that has them.
And the county does have traffic counters that we can use.
May I, since,
Go ahead.
you know, I just wanna say, first of all, I'm not a road use person. I just picked up some things. I believe that with respect to, and I'm gonna talk about the road use law and not the road use agreement, because an agreement, there's nothing to enforce, obviously. I think, from what you're saying, what I'm hearing you say, is that you might not mess around with the expense of a road use law, because you don't know, you're sort of conceding, I think, forget the gas people, just with the logging people, you're conceding that these guys are gonna wreck your roads. And I think what you're saying, what I'm hearing over here is, but you don't think you can afford to have a road use law, to say no. Even if the state, or if the county doesn't do it, I think, I can get an answer for you on this too, I think you can essentially create, this isn't the right word, but create a deputy. And you can actually empower somebody to, essentially, yeah, I mean, I'm not saying, I don't know who would want the, but if the issue, if they're gonna tear your roads up, that, you know, the unpaved ones are probably 200,000, I mean, I don't know, you know what they cost to, it seems, if all if your only issue is enforcement, I bet you we could find a way that you could, as long as you were willing to pay this quote deputy, you'd have somebody to at least write appearance tickets, because you guys don't have your own code enforcement officer, right?
You'd have to have a constable to do that.
Right, right.
One of the
You know what it
things,
costs to get a constable?
I don't.
10 grand.
Well, you know what it costs to repair these roads?
Huh?
yeah,
But you know what it costs to repair these roads?
but you know what, we do have a road use law in the town.
We do.
Okay.
Basically for posted weights and
No,
stuff?
actual road use law.
Okay.
We do have a road use law. I brought the road use law to the loggers or companies that are doing major work on our roads. And there's an actual worksheet that they have to fill out. They don't fill them out. They don't get them back to me. They do the job. It's on a they're doing a state contract, a logging job. That's when I went to the sheriff's department. They said, we don't have the ability to enforce.
You run it by Roger?
Yeah, Roger and I met.
What did he say?
It doesn't have a lot of teeth in it, you know, and it's the enforcement end of it. On who do we get to tell these guys you can't come into the town?
I'll look up what I can for you to see.
That'd be nice.
What are we gonna do about this self-engineering thing? I mean, how's anybody else feeling about it? $10,000, I mean, if you can't go out and tell the damage to the road, I mean, the road's gonna take so much gravel to fix it all. You can, definitely, I know you can figure yardage, so what do we need to spend $10,000 for? We already got you?
Right. Well, the one big issue is the individuals that have filled out the work order, there's supposed to be a bond with them. However, all these bids were done before this so-called road use law got enforced by myself. So those guys that put those bids in on those properties, to be fair to them, they didn't figure in a bond in the bid. So, you know, I waived them and discussed it with them, and they've been very good. There was a logging company that had somebody else hauling, and the guy that he had hauling the logs wasn't on the same page as the logging company. So we discussed it, and, you know, they're gonna cease and desist what they were doing. But it's the bond, now the price, the amount of the bond, the town clerk is, according to the road use law, the town clerk is supposed to have how much the bond is gonna be.
Who
And
sets it? The board sets it, though.
the board set that. Now, do you have the chart? You don't. Oh. Well, and, you know, now if you go with German, German's is 10% of the total bid price, but no more than $5,000 for a bond. So, you know, you had a bid of, I think it was $900 and some on Pike Road. There was a little spot that they logged, little couple acres. It was a $900 and some bid. So that would be $90 in a bond. What's $90 gonna do? That's not even gonna get me up there with a wheelbarrow. You know, I mean, but that's where you're at.
I think a lot of this road use law too is, I was already talking to another supervisor in another town, which I wouldn't say who it is, but they're talking about a road use law because of the gas companies coming in, that they want bonds around $50,000.
But I don't think you can expect
A logger to pay that.
a small individual that's doing logging, or, you know, just 2 or 3 guys that are doing rock picking on stone walls to afford a $50,000 bond. I mean,
But and the 10%, it don't amount to anything anyway.
Well, see, with theirs, with their law, a lot of that stuff wouldn't have even fallen under that.
correct, logging wouldn't have fallen under their law. Absolutely, because there wasn't enough easels.
Not enough trucks.
Right.
Truck down the road.
Right, not enough axles on the road. True. That, the logging wouldn't have been covered by the Delta Road program. At
Which
all.
we'd still end up with the same problem we've got right now.
Let's keep it at 10,000.
Well, the logging has been going on here for decades upon decades, with trucks going over the road, and there are times they are a mess, but they have survived. I mean,
Well, they gotta survive, because we gotta keep the road open.
well, that's true. And I said to Tom, you know, when he works the roads in the summertime, and you get, the rain pours down the next day, the roads look as bad, if not worse then, than they do during spring break. Being on the right road, on the right day in the summer. I mean, I've made the statement before, I'm in the business, it affects me, but this whole thing with road closing, you might as well just put the big sign out there that says log trucks, not permitted to be on this road. Because the reality is, you're not gonna stop anybody else. Whether it's a school bus, a gas truck, a milk truck, a hay truck.
There was a survey out a while ago, which I read in, I think, to tell you the truth, was that Town Topics, that the worst enemy of the town road is their own trucks.
Oh, there's
There you go.
There's no doubt. If we had to go out on the roads right now with a load of sand on them, we'd do just as much damage, if
That
not
log
more,
truck.
Or more.
or
Probably
more than a log truck. There's no
Because
doubt about that.
we're 80,000-90,000 pounds on 3 axles.
And I, looking at, Tice Road the other day, where Gary Lobdell's gone up through there with his tractor, I mean, you talk about a nice set of rumble strips, you know? So it's just, you know, the way it is.
What's he doing?
He's going over to, who's that woman there on Simpson Road?
Weights.
White.
Oh, or Pat.
But, you know, the big thing is the dirt roads are a little bit easier to fix, but the oil and stone that you put a lot of money into and then they tear them up, they are hard to get back unless you're gonna do a whole bunch of patch.
We got a little work on Corbin Road there now.
Oh, yeah. Yep.
Well, back to the agenda here. What about Delta Engineering? We want it or we don't want it?
Well, I don't think it's something we need to make a decision right now anyway. You know, whether it's this month or next month, it's not,
Well, first place, it would help you out with your decision. Where's the money coming from? What part of your department is it from?
Like I told you, I'm not giving up any more of my money. You gotta take that out of your, you gotta take that out of your secret stash you have there. What's it called?
contingency.
Yeah, there you go.
Yeah, we'll cover that. So, other words, there's no money for it, so you can forget it. No money budgeted.
I guess I'd go along with what John's talking about. We don't need to make that decision tonight. With what we were presented by David, we certainly have a lot to chew on here this next month as far as a moratorium, whether or not we do or we don't. And if we end up going down that road, then maybe that's something we definitely would want to consider to,
Well, when you get to make your decision, you tell me in the budget where it's coming from.
Well, the thing is, and what,
Taxpayers.
I can understand what Terry's saying now. If, believe me, if there was a moratorium put in, that would give you time to work on a road use law and time for next year's budget if we needed the $10,000 for the Delta Road program. You could put that in next year's budget because you'd have a moratorium. And then I'll just fight with the loggers during this wet weather.
Well, one way or the other, you're gonna pay.
Oh,
Whether we pay Delta Engineering or whether we hire somebody to patrol and do this,
I can't see what the hell you're gonna get out of Delta Engineering. What
you know,
else you're gonna pay?
we're gonna pay. The next thing is, look what we went through trying to get our last enforcement officer. You know, how are we gonna make out this time around?
You know what it boils down to, the end of the trail.
Fortunately, you know, we begged and pleaded to get one, and actually had to double the salary, I believe, to get one that lasted 6 months and was on his way.
And the only thing that cleaned up anything was the
And
price
still
of
no,
iron.
and still no action.
Still no result. That's-
well, to move things along, I make a motion that we
Wanna table it?
table it till next meeting. And we'll bring it up for discussion again at that time.
I'll second it.
Any more discussion on it? All in favor?
Aye.
Aye, okay. Now, the school bus garage, I don't need to read the letter, because Roger already told you all about that. So, under new business here, there's only one thing left here. Let's find it here. Would you read the resolution, please?
Resolution 2013, number 6, Supervisor Arrington J. Knorr offers the following resolution for adoption. Transfer $1,000 from A 1990.4 contingency into A 1220.4 supervisor contractual for the purchase of a new computer.
I'll second it.
I'd just like to make a comment before we get to that. Talking with Tom a little earlier before the meeting, there was some question as far as the cost per month of the phone service or internet
Yes.
service. That there seemed to be a mistake that you had. You want to
Yep,
fill in
yeah,
on
our,
Not in the
Wait a
middle of
minute,
a
we're right in the middle of a
resolution.
resolution, we gotta
Okay.
finish this.
that? Okay.
Let's do a roll call.
Yeah. Okay. Sorry about that.
Councilman Barros,
Yes.
Councilwoman Beckwith,
Yes.
Councilman Harvey,
Yes.
Councilman Tracy,
Yes.
Supervisor Knorr.
Yes.
5 in favor, 0 opposed, 0 absent, motion carried. Tracy?
I did.
Okay.
Now we can hear about the,
we didn't have to hear about it really
Okay.
at all, but, I received a phone call today that since I got internet in the town barn, that my phone bill with the internet was $255.50. Well, after I picked myself up off the floor, and, I called Frontier, and there was a mistake. It's supposed to be $99.98 for unlimited long distance in the internet service. So it's all gonna be credited back to the account. It'll be 2 bills before it actually fully shows up back to the $99.98, but they apologized, so.
else got anything you wanna bring before the board at this time? Okay. I know everybody's chomping a bit. Well, it's public comment time.
I'm Tammy Reese, I'm originally from Oxford. I'm a fifth-generation farmer from Shenango County and have family and friends living in the towns of Oxford and McDonough. After listening to a lifelong friend from Oxford that moved to Colorado explain what the natural gas industry is doing to her town and seeing firsthand what the oil and gas industry has planned for us while driving the back roads of Pennsylvania, I will no longer stand by quietly. Citizens of New York State are no longer afraid of what the oil and gas industry has in store for our small towns when it comes to horizontal hydrofracking, because we are fully informed and now are downright angry. We have all the facts when it comes to taking our property rights through compulsory integration into gas wells. We will be forced to participate in heavy industry, gathering lines, and the devaluation of our property and health for our families and livestock. Residents will lose even more rights when eminent domain is used to run larger volatile natural gas pipelines and compressor stations on our properties, which is unconstitutional. But when you have enough lobbyists, anything can be made illegal. I have fond memories of hunting and fishing with my dad in McDonough and Oxford. My family is a proud family that knows how to live off the land, as many families do in Shenango County. And he was a logger, so you're probably one of them that you... When my niece and nephews come to me and ask me where I was when our elected officials were deciding their future, I can say with a clear conscience that I was trying to give them a voice by standing here tonight and looking into the faces of the people that will carry the burden of knowing full well what fracking and heavy industry will do to our towns and the Empire State. I would like to also mention that I now live in Otsego County, only 20 minutes from Oxford. In the town of Butternuts, the residents of Butternuts has a moratorium on horizontal hydrofracking, waste pits, spreading of flow back on local roads, heavy industry, and storage of chemicals and contaminated mining waste. We have a 9-month moratorium because we're trying to get our comprehensive plan in place. And Mr. Slottje, thank you. He's been by our side through the whole thing. Him and his wife have helped us. He won't let you down. There was a letter printed in our today's paper, the Daily Star. And this gentleman, he's dealing with the Constitution pipeline. And this is an issue that a lot of people need to think of, because you may have to put the time up front, but it's going to help you in the long run. The letter reads, recently I learned that my town council has been counting chicks long before a hatching site of any eggs. I had a conversation with another pipeline affected property owner. He said the assessor has calculated just how much tax revenue the town can expect should the proposed Constitution pipeline be built. I was repulsed by the thought of our town leaders rubbing their hands together in anticipation of receiving an insignificant reward from the Constitution pipeline for allowing the degradation of the property of those citizens who happen to be in the way. But that's not my reason for writing today. First, if I had the many other citizens, the many other citizens working in opposition to the pipeline, and the gas drilling it foreshadows. Succeed, the Constitution pipeline will not be built. Assessors would be wise to put down their pencils until they know there will actually be a pipeline tax. Should we fail to stop the pipeline, it will be years before construction is complete. Even then, we have no idea what sort of giveaways the pipeline developers might extract from the state and local governments that will negatively affect the pipeline assessments. Plenty of time for the pencils then. Lastly, if a pipeline is built, each property owner of which an easement is acquired will demand a downward reassessment of between 10 and 50%, depending upon the impacts of their particular easement. More significantly, when the gas companies commence drilling, we will see property values drop by at least 25% all across the affected areas. The loss of assessed value will become critical as families cash out, pick up, and leave rather than live with the effects of fracking. The inability of potential buyers to source mortgages will drive property values down even further. Do you see where this is all going? There's even more information. Being a farmer, Lancaster farmer has a lot of stuff that's there to read.
He had his hand up.
My name's Steve Elder, I'm from McDonough. I didn't bring a long agenda today, because I usually do. This has been a long night, but anyway, I'd just like to ask the town to take seriously the, putting a moratorium to give ourselves time for the road preservation laws and, putting a law to prohibit spreading of brine, and then time for the concerned citizens of McDonough to do our survey. And
Well, how long is that gonna take in this survey?
I don't know, how long did it take in Middlefield?
We started with a phone survey, a written survey. We gave ourselves, it took a matter of probably, when we did the written one, we gave ourselves between 3 and 4 months. By the time we drafted it, mailed it out, this is with the phone survey, to make sure we got responses from
I don't
everybody.
want to show phone survey because.
What I was saying, we did a phone survey, so we had, that was faster. When you do a written survey, you have to draft however you want the language to be, you draft that. Then you need time to, get it all mailed out, and then you have to give people time to respond and tabulate that. So you're gonna want to give yourselves, depending on how quickly they can get it together, probably at least a couple of months.
So I guess that's the answer, a couple months, 2-3 months. Anyway, so one other question I have, I've done a lot of data mining for the town, to try to get you information on what other towns are doing. And I see that the Delta Engineering thing is up in the air. Would you like me to give you road preservation laws that other towns are using? Do you want me to give you another set of those? I think there's about 6 different towns that have different road preservation laws.
I think I've got most all of them, Steve, that you sent.
Oh, I have one.
First of all, I'd like to.
First, your name, please.
Oh, my name is Annette Van Still. I'm from the town of Pharsalia. My comments include an assumption, a question, and then a statement. First of all, the assumption that I want to put before you is that each of you were elected to protect the health, safety, and welfare of all life in McDonough. That means all the people, all the animals, the water, the land, all life. I mean, that's really your primary role, to govern, to protect that. And then my question is, what's the population of McDonough, just not taking animals and all the rest, but just people? How many people in McDonough?
872.
I'm sorry?
872.
872.
872?
Might be down to 807.
Is that true?
Yeah, okay, keep it up there.
Okay. So, of that 872, how many properties are leased? How many properties in McDonough are leased?
About 90.
I'm sorry?
About 90, give or take,
90?
roughly.
90. So, the way the county stands at the present time, from my point of view, is that the county and all its towns are governing to protect only the property rights of these 90 property right owners, and in Pharsalia it's 29, so you're governing to protect their property rights. And all our rights, whether they're inalienable rights for clean air, clean water, good soil, which are really the rights that you have also as a landowner. We know that they're violated by this industrial process. It's not anything new. The facts are out there. We know the water is contaminated, the air is contaminated, the soil is contaminated. We know that. So currently in our county, every town stands with only governing for the property rights of the corporation, because when you lease a piece of land, you become part of the corporation. And all the rest of us, my property rights are not protected. I'm not leased. And by compulsory integration, my property rights are subject to industrial fracking, hype fracking, and I have no right, I have absolutely no right. So when the right of a landowner that leases prevents me from having my inalienable right protected, to me, that is an unjust, unequitable, and untenable position. So I think when towns look at this, their only conclusion can be that they govern for all people in the town in relation to what they promised as an elected member of the town to protect the health, safety, and welfare of the town. So it's very curious to me that you have such a hard time, that man said it's a hard decision. It's an easy decision. You either govern to protect the right of these landowners, or you govern to protect the rights of everyone, including you, because every landowner that has been leased has to drink water, has to breathe air, and has to have food from the soil that they're willing to contaminate gladly for the money that they receive. Economic benefit was the lawyer's big thing. So I really just want to at least have you consider that from the point of rights, to consider whatever they are. Thank you.
Hi, my name is Nancy Duffy, everybody knows that. I would like to submit, if I can, to the lovely Donna Preston, a meager 8 additional signatures, but I'm happy to tell you it brings us over 250. Somebody just handed me a couple of sheets further, so you'll get those next month. We have about 600 voters, less than that in the town, and I think the only reason this number isn't higher yet is because we didn't knock on enough doors yet. But to me, that survey started when I got out of my car and knocked on the first door of a stranger back in September to ask them how they felt.
Who's next?
Everybody's tired.
It's early.
Early, you haven't been up since 4 o'clock,
Yeah.
have
I'll call you in the morning, Art.
you? Yeah.
Time change is killing
I
everybody.
passed you this one, didn't I?
Hi, Kelly Brannigan, Town of Middlefield. Just a couple of things. When it comes to the road use plan, Delta isn't the only outfit out there. There's another one, begins with
You're
an
just out
L.
to spend our money.
Huh?
You're just out to spend our money.
No, I say, if you don't want to spend money on Delta, there are other outfits that you can have give presentations, and I'll get the name. I had it on the top of my head. It begins with an L, I think. But, so you're not stuck with just Delta. So you can look at, some of these other groups, or, as you said, take a look at the road use plans that are out there. There are a number of towns that didn't use Delta or another outfit and have crafted their own road use laws. Definitely you want a road use law, not just to protect your town. If somebody else is doing some kind of heavy industry for the traffic that's coming through McDonough, you want those protections as well. Make sure that whatever industry it is pays for those costs and it's not on your taxpayers. You are talking about a moratorium, which I think is a good thing. A couple of things you need to look at. I don't know if you have a volunteer fire department, take a look at your first responders, what the numbers are. Do you need to beef up their training? The resolution you were handed saying just let the DEC do their thing. The problem is we don't know what the DEC's regulations are going to look like until they come out. If you have no protections in place, if you don't have a moratorium, you're subject to whatever those regulations look like. As prior regulations, what we've seen, they aren't very protective. 500 feet from somebody's home is not a very protective regulation. The other issue is if the DEC decides that they aren't going to issue regulations, but they're going to do the permits without regulations, then you don't have any regulations at all to protect you. You don't even have that 500-foot buffer. So to sit back and wait for the DEC, you're much better off saying, okay, we're going to take a time out here. We want to see what the DEC is coming forward with. If they have great regulations and you're happy with them, you wanna move forward, as Mr. Slottje said, you know, you can change your minds anytime. You can't go backwards, but you can always go forwards. So if you decide you need this moratorium to give you time to look at your road use laws, to ask the people of your town what their vision is for your town. I don't live here, I don't know what your vision is. I don't know if you guys want to move forward with drilling or you don't. That's a discussion you guys have to have with the people that live here in your town and find out what their vision is. But give yourselves that time. A moratorium isn't some big scary thing. You know, it's just that time where you don't have to rush. You can sit back, listen to people, get your road use laws in place, take a look at the hazardous waste on the roads, you know, get those things all in place. See what the people in your town want, and then move forward with that. You know, this is a decision, as I said, between you guys and your townspeople, nobody else. Thank you.
Okay, I guess nobody else has anything else to say? All right.
Just real quick, my name's Robert Yates. Just want to remind the board that this money that everyone's talking about is temporary, and we're all going to have to live here permanently. I'd also like to remind you that the Landowner Coalition does not represent all landowners in McDonough. In fact, 14 of the people that have signed leases have now signed the petition. And there's many members of the Landowner Coalition that have not signed leases that have also signed the petition. That's really all I got to say.
One comment. Yeah, I'm Kenneth Fogarty, I'm from the town of Guilford, which I can almost see McDonough from my back porch. I can't see Oxford. I guess you're over the next hill. So I would just like to thank the board for inviting David Slottje tonight. And I know it's a very difficult issue. And also would point out that waiting for the DEC is one thing, but the DEC is often waiting for towns. The DEC has asked towns to investigate if there were any peculiar assets that they should know about while they issued permits. For example, I was driving nearby recently and I saw people stopping at a spring and collecting water to drink. Those things aren't known by the DEC, so when one has a moratorium in place, one can take an evaluation of these kinds of assets that only the local community knows, and then perhaps put some kind of restrictions on land use near those assets. So once again, thank you very much. I know that this is a very difficult issue. It takes a lot of time. And thank you for your patience, and thank you for inviting David Slottje.
Anybody else want to speak on anything? Okay.
Make a motion that we close the board meeting.